afternoon, everyone. My name is Kathy Brown from Brown & Brown of Connecticut. I'm so thankful for all of you joining, taking the time. I know schedules are busy, especially for folks like Andrea and her team. So I do want to be mindful of that and welcome everybody. This is a hot topic. We know that the first remittances are starting to flow in, and the Paid Leave Authority is hard at work trying to make this this come to life. So without further ado, I do want to welcome Andrea and say thank you for taking the time during such a busy time for you and your team. But I did want to just give you all a little bit of background on who Andrea is and how she got to where she is. She was appointed by Governor Lamont on January 23rd, 2020, and began serving in this capacity on March 2nd, 2020. Prior to this appointment, she served as president and CEO of HARC, Inc., a large not-for-profit provider of services for people with intellectual and related disabilities and families. She's also served as the organization's vice president of administration and in-house counsel. And prior to joining HARC, she served as the director of program operations at Lawyers for Children America and in the insurance industry at Chubb. She is a valuable asset right now today for our team, and for those of you who are on the call, I think you'll enjoy what she's got to share. And when she is finished kind of going through some of the educational components of keeping us up to date on what the latest and greatest is, she's going to open it up to some questions and answers. So again, everybody, thank you so much for joining, and I hope that you find this useful. And Andrea, I'll let you take it from there.
All right. Thank you, Kathy, and welcome everyone. As Kathy mentioned, I am Andrea Barton-Reese. I'm the CEO of the Connecticut Paid Leave Authority. With me today, I have Amber Forrest, who is our executive assistant at the authority. So just a few housekeeping matters before we start. If you have questions, please place them in the Q&A. That is the best way for us to monitor all of them and either answer them directly in writing or to hold them until we get to the end of the presentation. When you put them in the chat, it's much harder for us to monitor and track them. And this will take about 20-25 minutes, and then we'll open up the rest of the time to questions. So I'm just going to go ahead and get started. Okay. And let's see. Okay, then let me get started here. All right, so let's just start today talking about the paid leave law. We'll do that. We'll go through a basic overview of the laws. We'll talk about the role of the employer and what employees need to do to apply for their benefits. We'll give you a few examples of how paid leave will work in the workplace. We'll have a discussion about private plans and registration. I'll show you where on the website there are additional resources for you and your employees, and then we'll have a question and answer session. Just a little bit about the Paid Leave Authority. It was signed in the law that enables the Paid Leave Authority was signed into law of July of 2019. So we're coming up on just 2 years after the law was signed. And the authority was created as a result of that law. We have a mission, which is primarily to provide pathways to accessible paid leave benefits for Connecticut's workforce. And then we also take great pride in being able to help employers and administrators and healthcare providers by giving them tools so they can understand how the law works and to help them navigate the program. We have 5 primary responsibilities. They include outreach and engagement. So again, thank you for the opportunity to be here today. We develop the policies and the procedures that are needed to run the program, as well as establishing the trust fund contribution rate, which statutorily cannot go above 0.5%. We audit and approve private plans for those employers that opt out of the public plan and decide to stand up their own plan. We do review those and approve those, and then we administer the claims for paid leave benefits starting in 2022. Here are some key dates that you should be aware of. We opened our web portal for registration in November, which seems so far away now, and we've had over 70,000 employers register. Employers were deducting employee contributions to the paid leave trust fund starting in January. And for those employers that had determined that a private plan was a better option for their employees, they began that private plan process in February and are submitting those applications now to be approved no later than the end of this month. The quarterly electronic payments of the contributions being withheld are due right now at the end of March with a grace period that is outlined in the dates that you see there. Our plan is that starting in December of 2021, we'll have employees begin to apply for paid leave benefits so that they can get access to those in January of 2022. So a bit about the employers who are actually covered by the paid leave law. The paid leave law covers employers who have one or more employees working in Connecticut, and that does include all not-for-profit entities and private sector employers that have a unionized workforce. There are sole proprietors and self-employed individuals who may opt into the program, and if they do so, they must remain in the program for a minimum of 3 years. Those covered employers that are excluded from the plan are the federal government and the state of Connecticut, that meaning those that are in a bargaining unit, and I'll describe that more clearly in a moment. Municipalities and local or regional boards of education, with some exceptions as well. And the one category of employer that is completely exempt are non-public elementary or secondary schools, also known as private or independent schools, because they have not participated in FMLA traditionally. So what exactly is a covered public employee? It is a non-unionized employee of the state of Connecticut. And those unionized employees in the state have the option of collectively bargaining to be included in the program, which is a little different than employees of municipalities or local or regional boards of education. If employees of a municipality or a local or regional board of education opt into the program by collectively bargaining to be included, and if the same is true for a local or regional board of education, then all of the employees in the municipality and all of the employees in the local or regional board of education are included in the program, which is a little different than what happens at the state. So you can see that at the bottom of the screen, a municipality has a very broad definition that can include a town, a city, a borough, and can extend all the way out to a tourism district or a flood commission. So we're getting close to the date when contributions that have been withheld since January are due to the Paid Leave Authority. And here is a brief diagram, a diagram that briefly describes how this process works. First, contributions are post-tax, and they are based on the employee's wages as they are calculated for the purposes of FICA. And those contributions are capped at the Social Security contribution limit of $142,800. The contributions of 0.5% of wages are remitted through the employer to the Paid Leave Authority. We then validate that wage information with data that we receive from the Department of Labor and also from the Department of Revenue Services. The contributions are deposited into the Paid Leave Trust Fund, which is managed by the Office of the Treasurer, and that trust fund is what is used to pay the paid leave benefits. Here is an overview and a comparison of the law, the Family Medical Leave Act, as it currently exists and how it will change in 2022. What's really important to know here is that the law itself in Connecticut is going to change. And then there is the additional component of a family and medical leave now being paid. So starting with the current FMLA, we now know that it applies to employers that have 75 or more employees. Those employees had to work at least 1,000 hours for 12 months in the period immediately preceding their request for leave. And they were able to enjoy job protection, the ability to get their job or an equivalent job back when they return from leave after 12 months of time with the employer. Once they've met those criteria, they had 16 weeks of leave available to them in a 24-month period, or 26 weeks of leave for military caregivers. And employers could require the employee to use all of their accrued time off to cover their time that they are away on FMLA. When the FMLA law changes next year, Some of the significant changes include the fact that it applies to all employers with one or more employees. There will no longer be an hours worked requirement, and job protection will attach after 3 months rather than 12. Rather than have 16 weeks in a 24-month period, there will be 12 weeks in a 12-month period, and the 26 weeks of leave available for military caregivers will remain. There will be, however, an additional 2 weeks of leave that may be available for incapacitation during pregnancy, meaning that a person can have up to 14 weeks of leave when those circumstances arise. And finally, the most significant difference between the current law and what will change is that the employer can require the employee to continue to use their accrued time off, but they must allow them to keep up to 2 weeks of their accrued PTO, and they cannot force them to exhaust their leave to cover their time away under family and medical leave. Here are the reasons for leave, and they are also the same reasons for income replacement benefits under the law. You can take leave to create or expand your family through birth, adoption, or foster care. You can also care for a family member with a serious health condition or your own, even if you're serving as an organ or bone marrow donor or for pregnancy. There is special leave available, as I mentioned earlier, for a family member that has been injured during active duty. There's also qualifying exigency leave for when a family member is called to duty overseas and they have to take care of certain concerns that might be childcare and the like. And what is unique to Connecticut's law is that the Family Violence Leave Act permits up to 12 days of leave to address issues that arise for victims of family violence. Those victims of family violence, also known as domestic violence, will now be able to apply for paid leave for any part of the 12-day leave. Here is just a snapshot of the leave and paid leave benefits under the FMLA for federal and state, defined by job protection and paid leave benefits. So federal, as we just mentioned earlier, remains the same. It's 12 weeks in a 12-month period with 26 weeks for military caregivers. FMLA, job protected leave, remember that attaches after 3 months, 12 weeks in a 12-month period. Military caregiver leave, family violence, 2 weeks for incapacitation during pregnancy. And those same lengths of time for leave apply when the person applies for paid leave benefits. Just a reminder that Connecticut FMLA, when it changes next year, will be added to the array of laws that provide job protected leave under several statutes. Again, federal FMLA remains available. Connecticut FMLA will now apply to all employers with one or more employees. Workers' comp, the Americans with Disabilities Act, Pregnancy Disability, and the Connecticut Fair Employment Practices Act will all remain viable laws under which an employee may seek job protected leave, even if it is unpaid. Income replacement remains available under workers' compensation, and then there will be the addition of the paid leave law effective next year. But what's notable here is if a person is receiving workers' compensation benefits, they may not receive paid leave under the Paid Leave Act at the same time. The eligibility requirements for paid leave are outlined here. Again, eligibility for federal, eligibility for job protected leave under the new law next year. But for paid leave, a person has to have earned at least $2,325 in the highest earning quarter of the past 4 of the 5 quarters immediately preceding the time that they apply for leave from the Paid Leave Authority. And those earnings can be earned from more than one employer. They obviously have to have an existing reason, a qualifying reason for leave, and they have to have not exhausted their leave time. In addition, they need to be currently employed and working in the state of Connecticut, or they have been employed and working during the past 12 weeks immediately prior to the time that they apply for leave. Again, a sole proprietor or a self-employed individual who's opted into the program may, of course, also apply for paid leave benefits. One of the other primary differences between the reasons for leave under federal FMLA and the state law that will become very apparent next year is the expanded definition of family. So under federal FMLA, an employee can take time off to care for a parent, a spouse, or a child who's under 18, or if they're over 18, that child must have a diagnosed disability. In 2022, the Connecticut definition of family will be expanded, and it will include all of the categories you see listed here: parent, spouse, son or daughter of any age. So the age restriction goes away, and it is then it is agnostic as to whether or not the person has a disability. Grandparents and grandchildren are also included, and they will be next year, or any individual with whom the employee has a relationship that is an affinity to any of the relationships listed in the statute. So what exactly does that mean? Related by affinity means a relationship with any person with whom the employee has a significant personal bond that is one like family, or the family relationships that are listed in the statute, regardless of the biological or the legal relationship. And of course, this is situation specific, and the family relationships listed in the statute are the ones that you see here. So it's not virtually every relationship you can think of. The one that seems to be most accessible and understandable, and quite frankly explainable when we're trying to determine what related by affinity means, is perhaps the second bullet, where you have a couple that may be living together. They've lived in a familial spouse-like relationship for some period of time. If one of the persons who regards themselves as spouse of the other were to today have to make medical decisions for that person, or accompany them to an appointment, or any of those kinds of things, that would not be something that they could do and take family and medical leave time to do that right now. That will change in 2022 with the appropriate documentation. That person, despite their lack of a legal relationship to one another, would be able to care for the person they consider to be their spouse. What happens when an employee comes to you and asks for paid leave, or FMLA period? We're asking employers now to consider engaging in a two-part analysis. The first is to ask whether or not that employee is eligible for job protected leave under one or more statutes, as I mentioned in the earlier slide, or I should say, whether the employee is also eligible for any income replacement while they are out on leave. And the reason why both questions must be addressed every time, this is HR people, is that there may be a circumstance where one applies and the other doesn't, or vice versa. Eligibility, as we know, for job protected for leave can fall under federal FMLA only, or state, or both running concurrently, or neither, but as a job protected leave as a reasonable accommodation, perhaps under the Americans with Disabilities Act or the Connecticut Fair Employment Practices Act, or there might not be any job protected leave at all, and that's why the person would need to have income replacement as a question that's being asked as part of the analysis. And I'll stay on this slide for just a moment so I can explain that last bullet. Here, there will be circumstances under which a person may not have job protected leave under the Paid Leave Act, but they may be eligible for income replacement. And that is because the person, having earned that 2325 I spoke of, having had a reason for leave that's covered under the statute, having not exhausted their leave and meeting the criteria of working in the state or have previously worked in the state for the requisite amount of time, that person would be eligible for paid leave benefits, but they would not be eligible for job protection. And that's why asking this question about the eligibility for income replacement while on leave is a critical one, because they may not have job protection. All right, so a bit about income replacement. Benefits coordination is a question we get quite often, and an employee may receive benefits from the Paid Leave Authority and any employer-provided benefits like short-term or long-term disability at the same time, but those combined benefits cannot exceed 100% of the employee's regular wages. As I mentioned earlier, short-term and long-term, the workers' compensation and paid leave aren't things that can be collected at the same time. They are, in fact, mutually exclusive by statute. I just discussed the paid leave without job protection. I'll go into a little bit about private plans. And then again, a reminder about requiring the use of accrued time. Many employers that we have communication with are saying that they are either staying with their policy that requires their employees to use their vacation or their sick time while they're out, and just allowing them to hold back those 2 weeks. And that is to prevent what we call stacking, which is having an employee hold on to their time for vacation and not use that and then use their paid time, use their paid family leave time and end up with extensive amounts of time off, which some employers find that is undesirable given the needs and business needs of their workplace. So what happens when an employee wants to access their benefits from the authority? They do that by applying directly to the paid leave authority. So employers are making a decision about whether or not the employee has submitted appropriate paperwork to ask for the time off. And then they come to the paid leave authority for their benefits. We do that by validating their eligibility using the criteria that I outlined earlier, including the reason why they're seeking benefits. We then do a preliminary calculation, but we also go back to the employer to make sure that the employer is aware and that we validate their actual covered absences and to see if in fact there are any offsets through employer provided paid time off. And that could very well be the vacation, accrued time, or any other type of time that the employee is required to use that would also then offset the amount of benefit they receive. And then the authority, after having done all of that validation, including data from the Department of Labor to validate wages, we then issue benefits payments. So how much are those payments? We get this question quite often, frankly. The formula for paid leave benefits is in two parts. If the employee's base weekly earnings are less than or equal to the minimum wage multiplied by 40, which right now is $12 an hour, so it's $4.80, that person receives 95% of their covered employee base weekly earnings. If they earn more than that, the formula is a bit more complicated. They get at a minimum the $4.80, and then they get the difference between what they make and the $4.80. That would be about 60% of their weekly earnings. And there's a formula, there's an example after this that I can show you. But the maximum that anyone can receive, is 60 times the minimum wage, which is $720. So here are a few examples of applying that formula in its two parts to two different employees. Mike is example one, who makes less than or equal to the minimum wage multiplied by 40. So he makes less than $480, coming in at $375 a week. His calculation is really pretty simple. We take 95% of his base weekly earnings, and that brings him to $356.25. Deborah, on the other hand, makes more than Mike does, and she makes more than the minimum wage multiplied by 40. So she comes in at $700. She starts at the $480, and then she makes 60% of the amount of the base weekly earnings. 60%. Then she gets 60% of the $220, which is her base weekly earnings minus the $480. So that is an additional $132, and so she ends up with $612 as her paid leave benefit. A couple of examples of how this might work in different sized workplaces with employees that have different amounts of time in service. So Mr. Coyote has worked for Acme for 10 years. It is a large employer with 100 people. He has 4 weeks of sick and 2 weeks of vacation. His employer requires him to use his accruals before he can access, any other benefit. So he hurts his hand in a non-work related injury. As we know, if it were work related, he would not be eligible. So let's see what his eligibility and his payments look like. Because of his length of time and his length in service, he is eligible for both Connecticut and federal FMLA for job protection. For paid leave benefits, his employer is having him exhaust his sick leave accruals, allowing him under the statute to keep 2 weeks of his vacation that he's also accrued. And he then will seek wage replacement benefits from the paid leave authority for the remainder of the time that he will be out. Jamie's situation is a little different. She works for a smaller employer, but remember the law changes, and so it covers one or more employees in 2022. So her employer will be covered by Connecticut FMLA. She'll have 6 days of sick leave and 3 weeks of vacation time. And she too has injured herself in a non-work related accident. So looking at Jamie's situation, she is eligible for Connecticut FMLA because she's been working for more than 3 months, but not federal because she's not met the federal criteria of either the hours worked or the number of employees. She then has up to 2 weeks of the time that she can use for her vacation. I think that's actually, and then part of it is her, for her sick leave and then her vacation. And then the remainder of the time that she will be away will be covered by her wage replacement benefits from the paid leave authority. Again, her employer requires that she exhaust her sick and her vacation, allowing her to keep the 2 weeks and then go to the paid leave authority for the remainder of her time. For those employers that have spouses that work for the same employer, under federal and state FMLA, the rules are very similar. As we can see, the spouses, they're required to share the 12-week job protection for bonding with a child that's new to their family or to care for a parent under FMLA, and for bonding for a child that's new to their family to care for a family member under state law. But when the leave laws change in 2022, the spouses will no longer be required to share their paid leave benefit entitlement for any of the reasons that he had previously. That will go away. So a bit about private plans. The statute does allow for employers to create their own version of the paid leave plan with very specific rules. And that section is 31490 of the Connecticut General Statutes. So when an employer has a plan that is approved by the Paid Leave Authority, they are responsible for administering the employee's claims. They are not required to admit any contributions to the Paid Leave Authority, but they can withhold a portion, but no more than the authority holds back, which right now is 0.5%, for the sole purposes of administering the plan. So they may collect that money and hold on to it in order to pay benefits, or they can offset the cost of administering the plan, but that money that's collected can't be used for any other reason. If an employer chooses to apply for a private plan, they simply go onto our website and they choose the option, I want to apply for a private plan, and then there are instructions on how to go about doing that. If you have not already applied for a private plan, it's too late to do it for this quarter. And we'll give you some more instructions on how to apply for the next quarter, because you had to have your plan vote and approval by March 31st. So that's not a deadline that's possible to meet for most good-sized employers right now. The plan requirements are these. They have to offer the same or better benefits as the public plan. In many, many cases, a short-term disability policy generally will not suffice because it does not offer a coverage for all of the reasons that the statute covers. Plus, a short-term disability policy can be had strictly on the part of the employer, but this statute requires that the plan be approved by a majority vote of all of the employees working in the state. And it has to cover all of the employees, and it cannot cost them any more than the public plan. There are a number of insurers that have agreed and have applied for and have been approved by the Connecticut Department of Insurance to offer either a surety bond for those employers that will be self-insured, or an insurance policy for those employers that choose to opt into a private plan. Your insurer has all of the information that you need in order to properly execute an application for a private plan. Okay, so you've heard about the basics of the program and the private plan, and you've probably seen me in a few places asking employers to register your business. So let me just pivot a little bit and talk about why this is important. It's the only way to remit the contributions that you're withholding that are due at the end of each quarter, starting at the end of this month. And we all know that employers are required to withhold 0.5% of wages to remit to the Authority Trust Fund, unless in fact you do have an approved private plan. So if you're not registered, you will not be able to remit those contributions, because we are not taking checks or any other form of payment. All payment is electronic and can only be submitted through the Paid Leave Authority. If you haven't registered, it is not too late to do that. If you go right to our website at ctpaidleave.org, it's one of the first things that you will see when you visit the site. It walks you through step by step. There is a video, there's information, and it takes less than 10 minutes to do. So what to do if you've not been withholding contributions? We hear lots of employers say to us, wait a minute, what do you mean this program has started? It's January. What do you mean we needed to start collecting in January? I don't know what's going on. And now it's March, and now you're asking me for money. What do I do? The first thing you want to do is start withholding now. The second is, if you haven't started withholding, or you started late, maybe in February or so, there is a catch-up period that we have negotiated with the Department of Labor. So businesses will have up until June 2021 to collect contributions retroactively from employees. You can do this by collecting up to an additional 1% on top of the 0.5% to catch up to make sure that you've collected all that you should from your employees had you started in January. You should really inform your employees if you choose to use the catch-up period, because if you don't tell them, they get upset and they call us. Believe me, we hear from them because some employers have exercised the catch-up period, but they've not told their employees what's been happening, and it doesn't make for a good outcome. It's another question we get. What are some of the possible consequences of not withholding? Not withholding can be a problem for employees who are looking to receive benefits in 2022, because one of the first questions we ask is, have you made a contribution to the fund? Failing to withhold the contributions in a timely manner and in full can mean that statutorily we can hold businesses responsible for making up those missed contributions or contributions that are short of what they should be when they are submitted. And there could be additional monetary penalties for failure to withhold and remit the contributions for employees. What we know, this is a very difficult time. It's one of the reasons that we went proactively to the Department of Labor and said, what can we do to negotiate this catch-up period on behalf of all employers, rather than forcing every employer to go to the Department of Labor and say, can I have permission to take out extra money? Because we know we need the DOL's permission to do that. So we don't want to get to this possible consequence slide. We want to make sure we're continuing to work with employers so that they can use that catch-up period. If they need to have it extended, that's a conversation they should be having with us so that they can be compliant. All right, so I've talked about a lot of things today. So let me just tell you where you can go and get some of this information. Definitely go to the website, to the employer section of the site, and you will find all of these pieces of information I have here and more. There is what we call an employee rights poster, which is a comprehensive summary of everything I've spoken of today as it relates to the benefits and the contributions that your employees will make. There's also a shorter version of that that's known as the employee rack card and the employee fact sheet. We just created it in different versions because we know people take in information differently. If all of this doesn't work for your employees, you can send them directly to the site where there are videos available in English and Spanish. This employee paycheck mailer that's at the lower right on the screen has been downloaded over 11,000 times. So although it's January 2021, if you have not started withholding, it is an excellent tool to inform your employees about changes that are coming into their paycheck. Finally, the Employer Toolkit is a 26-page guide that will give you everything that you need to understand paid leave, including private plans, speaking to your employees, any other questions that you might have. Our site again is ctpaidleave.org, and there are 4 things that we're asking employers to do immediately. First is to register directly at the site as soon as you can, and to start your wage withholdings if you've not already done that. If you use a large payroll provider like Paychex or ADP, they are well aware of this, and we've been working with them for close to a year. If you feel that they need a bit of a nudge, you should contact them directly, but they should be prepared. You should educate your employees about the withholdings with the information that I've shown you on the previous page and direct them to the website. And then come to the site regularly for updates, including recordings of webinars that we hold that are available on demand and on our YouTube channel. And we're here to help. We can be reached through our Contact Us portal at ctpaidleave.org. If you submit a question there, someone will get back to you, usually within 24 hours, sometimes a lot sooner than that. We do have a lot of frequently asked questions that people have found very valuable, as well as a number of helpful videos. So thank you for your time. I'm going to stop sharing, turn my video back on. Okay.
Thank you, Andrea. I'm just loading a few links into the chat for everyone.
Okay.
So I've dropped a link to our general webpage, which is ctpaidleave.org. And please register if you're looking for any of the employee toolkit documents. I've dropped a link in there for that. And also our YouTube page, which I'm going to share with you all right now, is where we have all of our other recorded webinars on a multitude of different topics. So we do have a few questions here in our Q&A. So we will start at the top and work our way down.
Okay.
My business is organized as an S Corp. I am the only employee. I registered my business with Connecticut Paid Leave in 2020 as required by Connecticut. No wages have been paid for 2021. I will be changing corporate structure from S Corp to single member LLC to
Let's
be
see.
self-employed.
Mhm.
What notification or documentation is required from me following this change?
You don't have any at all, actually. If you can go back in and change your registration, but it's actually really not required because although your previous corporate structure had you as an employee and you registered, if you have no wages to report, you can simply put in zero, and then we run a report of all the zero wages, and we're actually as information is coming in now, we're already kind of compiling that list. But you don't have anything else to do when you change your status. If you choose to remain in the program, then you have to do that for 3 years, but there's no other requirement beyond that.
Okay. And the next question is first on the other presentations. How will the entitlement be calculated?
The paid leave benefit?
I believe that's what they're asking in regards to, yes.
Okay, yes, sure. So I'll send Kathy the presentation, but there are two ways in which the benefit is calculated. If you make less than or equal to the minimum wage multiplied times 40, then you get 95% of your base weekly wage. If you make more than that, then you get the 480 plus 60% of the difference between what your wage is and the 480. So in the example that we have in the slide, that person was making $700 a week. So they started at the 480, then they had 700, I think was plus an additional $132 once you applied the formula. So that person ended up with $612 a week. So that is how the formula works. That's what the entitlement payment is, depending on your wages.
Okay. And coming from the same group, in regards to the calendar, from the first day of leave, forward, backward, rolling calendar year, can you touch base on that, please?
Yeah, we get this question a lot. So at the Paid Leave Authority, we are big proponents of rolling year, because if you can only imagine what might ensue if you use calendar year, particularly now since benefits are available for 12 weeks in a 12-month period. So what we want to do is to use the rolling year going back to count what eligibility would be. Otherwise, if you use calendar year, then someone could take leave in September, they have their 12 weeks, and then they're eligible again in January, which is really not the outcome that I think anyone's looking for. Plus, it's not the way that the statute was intended to work.
Okay. And also, this is the last one from the same group. If other employees that would otherwise be eligible to apply for Connecticut paid leave, but per company policy only have the 40 hours of paid sick leave per the statute, we would not be able to allow them to exhaust the PTO and leave 2 weeks behind. Is this serious, and do we need to enrich our PTO benefits moving forward?
No, you do not. You do not need to exhaust. You do not need to enrich your PTO benefit in order to allow people to have the additional 2 weeks. This part of the statute was not designed for businesses to add more costly benefits to what they're already offering. So I think I understand the question. So I know that there's the sick leave law, and a person has to work. I'm going to get the number wrong, but I think it's 680 hours. It's a lot of time that the person has to work in order to be eligible to get those 40 hours of paid sick leave. You don't have to then create a whole new policy that gives a person an additional 2 weeks just so they have something to hold on to. It's for those employers, some of whom have unlimited sick paid time off. There aren't very many of those. They've had to change their policy a bit to accommodate this particular provision of the law. But it's mostly for those employers that either offer a bank of PTO that's accrued over time, or for those employers that have the sick, vacation, and other types of leave. So that before, employers, like right now, if someone took FMLA right now, an employer could require that person to exhaust all of their leave. They could cover their 16 weeks, which they probably take now, since that'll change next year. They wouldn't use use it in the 24-month period, and then they'd be left with nothing for the remainder of the year. So that provision of the statute was designed to avoid that outcome. But it doesn't mean you have to give people more vacation in order for them to have something that's held back.
Okay. And to touch base on this is benefits running concurrently. Can you touch base again on the individuals that are collecting short-term disability and Connecticut paid leave concurrently, how that works?
Yeah, so it obviously depends on the terms and conditions of your policy. Some policies require that the person exhaust all of their state available benefits first before they can access their short-term disability. And in those cases, those people would come to the paid leave authority first. Some employers, when they require their employees to exhaust their leave, or employees choose to exhaust their employer paid leave first, it's because they want 100% of their benefit, because the most that we will pay is 95% if you're in that one category of employee, or you'll get less than 95%, quite frankly, the more that you make. And we've heard about the inequity of that, but that's the way that the statute is designed. So some people will say, I think I want 100, I'm going to need 100% of my wages for the first 3 weeks of the 8 weeks that I'm going to be out. So I'm going to use I'm going to use 3 weeks of my accrued time because I'll get paid 100%. Then I may access my short-term disability policy that might give me, let's say, 65%, but I still need 100% of my wages. So then I'm going to go to the paid leave authority and I'm going to apply for the difference between what my short-term disability policy pays and what I can get in benefits from the paid leave authority. We will be asking employers if that is an option that's available to employees, because we're going to coordinate those benefits. We're not going to have employees just come and say, I have a short-term disability policy, but I'm choosing not to use it because I want to save it for something else. That's not how the program is designed to work.
Okay. And if you've registered with only one employee and that employee is retiring in 2021, do you still have to withhold from their paycheck? We've had this question a lot.
You do until they retire. I know. We hear this a lot, but yes, because it is. And I know the reason that I always hear, and I completely understand this, because the person will not be able, they're retiring and they'll never be able to access those benefits unless, they do it. Well, they just won't be able to if they retire in 2021. And we get that, but it is, the way that I explain it, it's an insurance policy essentially. So it's every benefit is pooled, and not everyone that pays into insurance theoretically always gets the benefit of it. And that is also true for this program. So it is everyone paying into it. Some people will use it quite frequently, others may not use it at all, but we are all paying into it unless we fall into those categories of employers that are specifically excluded under the plan. So yes, unfortunately, they will have to pay into the plan.
Okay. So this one, I think this might be a multi-part, so bear with me for just a second.
Okay.
Municipalities, boards of education, and towns with unions. Brown and Brown previously asked the question regarding each union bargaining in the paid leave FMLA. Previous answer indicated each union would need to bargain in the paid leave before the entire district would be required to participate. Today's overview sounds as if you're stating that only one union within a district bargained for paid leave, that all employees in that entire district would need to be eligible for paid leave.
Mhm.
Has this changed?
No, it hasn't. So for those employers that have multiple unions, there isn't one union that can collectively bargain on behalf of all of the other unions. What we're telling employers that have that circumstance, and there are many more than I think even the drafters of this bill had anticipated, is that the best thing for you to do is to bring in your labor council and negotiate that on behalf of all of the unions at the same time. Because even by law, you can't have one union negotiate a benefit on behalf of everyone else who works at the workplace who belong to different unions and different bargaining units. So you do have to coordinate it. It's going to take some time. There are a couple of large employers that have actually been large private employers that have actually been able to do this. You might think some of the larger manufacturers in the state, they do have multiple unions and they have been able to pull those unions together and make a decision one way or the other. So it's feasible and it's doable, but it's not necessarily easy, but that's the way that we're recommending that you handle it. So that if you can get all those bargaining units together and they all agree, because those are two significant hurdles right there, and they all agree that they want to participate in the paid leave program, then everyone else who's not in the bargaining unit is also in the program. So everybody's in, whether they're in the bargaining unit or not, the way the statute is currently drafted.
Okay, thank you, Andrea. And I'm going to roll back to the calendar. We need a little clarification. So the calendar that this person is referring to is the FMLA calendar that was normally used to calculate available leave entitlement. So they want to know, are we using a rolling calendar, which we would be,
Mhm.
but she was waiting to hear the first date of loss going backwards. So the loop we're looking to look at
Ah,
12 months backward. During that 12 months, theoretically, some FMLA entitlement could have been used,
okay,
correct?
so I understand her question exactly. And the answer is, I do not have that answer yet because it actually is, it is a Department of Labor question. They make that determination. So we are still, they're getting close, but you can imagine they've been focused on other things at the moment. So they are very close to giving us their final recommendation on how they would like to have this calculated. But so we've landed on rolling year, but is it application or date of loss? They're very close to coming to a decision about that. And we'll announce it as soon as they do.
Okay, great. And is there a benefit between partnering with a public plan versus funding privately?
Hmm. So I guess it depends on the needs of your employees and what resources you have as an employer to execute a private plan. So remember, so the private plan is, you collect all of the premium if you choose to. Some employers are not collecting any premium at all. They're offering it as an additional benefit to their employees. You are then responsible for administering it. Some employers are doing this themselves if they're very small. Others are hiring a third-party administrator to do that. The benefit that most employers are articulating around this is that they like the fact that they have complete benefits coordination so that they're not sending their employee to the paid leave authority to make a decision about their paid leave benefits, and benefits coordination between short-term, long-term disability and any other kind of policy that the employer might have can be coordinated all in one place. So that's the benefit of doing it yourself. The disadvantage, of course, is that you're doing it all yourself, right? And so if you're a specific size and you have enough people, and you have enough people that are going to take advantage of the plan because they paid into it, it's going to be an additional administrative responsibility that you'll have. And I think some employers are determining whether or not that's worth it to them. If you just hold on to your short and long-term disability policies, obviously we all have to have workers' compensation. And then you send you think the few employees who may avail themselves of the paid leave program over to us, and then you have a couple of phone calls, and then we take care of everything else we will be using a third-party administrator as well for our own benefits administration. So we're not doing it personally at the Paid Leave Authority. We will be partnering with a third-party administrator well-versed in this space. And sometimes it's easier to do that and have that TPA on our behalf answer all the questions, track the leave, have regular communication with that employee as to when they're coming back, communicate with you, because all of those things still need to get done. Right? Somebody's got to do it. So it depends on whether or not you feel that you want to and can as an employer, or you'd rather have the Paid Leave Authority take care of that for you.
Okay, thank you, Andrea. And right now we're down to our last question. So again, if anybody has any questions,
Okay.
please submit them using the QA feature at the bottom of your screen. So our next question is, as a partnership LLC, just my husband and I have to register. We have had no income yet.
No, you do not.
Okay. All right, so that concludes questions for the moment. To give everybody another minute or two to submit their questions, I'm just going to grab the contact us link. We're here to help, and we want you to know that we are here to help. And our contact center is the best way to get in touch with us. So I'm going to drop the link to our contact us portal in the chat, and feel free to save that. So if you have any questions for us after this webinar, you can feel free to use that portal to reach us. All right, Andrea, it looks like that concludes our questions. So I'm gonna
Okay.
hand
So
this back.
Amber, let me just ask Kathy if she or any of her colleagues at Brown and Brown have any questions that have not been posed, or even if they have, I'll answer them again that you'd like to get some clarification on, because Kathy and I had I think a really great conversation about paid leave, and I was happy to have that. And it was out of that discussion that this webinar came about. So if you have others that I haven't addressed, then please, I'm sure some of your clients may have them as well.
No, I appreciate all of your time and this on the fly question and answer. The only question that I had, because I just becoming aware of that catch-up period through June. Is there a certain process for that? Like, do you have to file any paperwork or get permission that you're taking more out of the employee's paycheck to make that up at higher than 0.5%? Or is it just notifying the employee that we're doing makeup? We didn't do it in January, we're doing it now. Is there any formal process?
There is none, because we at the Paid Leave Authority have already done that for you. So you as an individual employer do not have to go to the Department of Labor and get a special letter. None of that. They've just issued sort of a blanket guidance and blanket rule that says that you're permitted to do this. We are strongly encouraging employers to just put a little letter together that says your paycheck may look even a bit smaller, and here's why, but you need to do this because you have to contribute to be eligible for benefits, and we want to make sure you don't have a problem. So you don't need to do anything else. And if someone were to object and perhaps file a grievance or a complaint at the Department of Labor, they'll still have the right to walk through that process, but it is far more likely than not that it'll be denied because DOL has already given all employers permission to do this.
Okay, that's great. That's great news. It's really helpful. I know that there's probably a few folks out there who haven't registered, so hopefully they're not.
Well, even if you haven't registered, it's really important that you withhold, because now because we opened up our payment portal just for those employers that said to us, we really want to just submit our payments now. So we've opened it up on a very limited basis for those employers. And we're getting some that have never registered, but they've clearly been withholding because they're submitting the appropriate amount of payment based on what we know their wage data is. So if you get in there and you register, please do that. But the withholding is really the most important thing, because it's not pretty if it doesn't happen. You just don't want any part of that. Okay. So I'm just really asking, just please withhold and remit, because that's the part that really counts the most.
Well, we heard it loud and clear, so we will make sure that we push our clients just to make sure that they're doing that. So thank you again. And Amber, thanks for putting this together and coordinating it. It's been wonderful. Really appreciate your time today.
Certainly. Thank you. Thank you for your time.
Thanks so much for having us.
Sure.
Thanks so much, ladies. Thanks everyone for joining.
Have a great day. Bye-bye.
Bye-bye.